Alright, welcome back. Let's get right to it. Civil Liberties and Civil Rights Unit 3 review. Alright, so what exactly are civil liberties? Well, they are guarantees of personal individual freedoms. So these are the freedoms that we find in the Bill of Rights, for example, things like freedom of speech and assembly, the right to bear arms, the right to be protected from unreasonable search and seizures. So these are freedoms that each of us as an individual or individual people that we possess. The Bill of Rights restricts the federal government's ability to infringe on our civil liberties. So notice that the Bill of Rights doesn't give us these freedoms, rather it is specifically restricting the federal government from being able to take those things away from us. Now, originally it was just the federal government that was affected by the Bill of Rights, but today, because of incorporation, which is one of the pivotal concepts in all of AP government, the Bill of Rights now applies to the states as well, limiting their power to, again, take away people's civil liberties. Incorporation is based on the 14th Amendment, and more specifically the Due Process Clause, where it says, "Nor shall any state deprive any person of life, liberty, or property without due process of law." Now, it's important to know that the Bill of Rights has been selectively incorporated, which means that rather than applying the entire Bill of Rights to the states at one time, it has been done on a case-by-case basis. In fact, as of 2018, excessive bail was just recently, just a couple months ago, selectively incorporated, so almost the entire Bill of Rights has been incorporated at this point. Alright, so let's get into the First Amendment, freedom of religion. We have two main clauses that are part of this religious freedom, the Establishment and the Free Exercise Clause. So the Establishment Clause is where it says Congress shall make no law respecting an establishment of religion. So it says basically there can't be an official religion, nor can the government give preferential treatment for certain religions over others. The Free Exercise Clause is what tells us that people have a right to practice the religion of their choice, or to not practice a religion if they don't wish to. Alright, along with that, we have two Supreme Court cases. One is an Establishment Clause case, and that's this one, Engle versus Vitale. 1962, this had to deal with prayer in public schools. And what this case ruled is that state-sponsored prayer in public schools violates the Establishment Clause. So that would be giving preferential treatment towards religion. So that violates the Establishment Clause, so this is going to limit the government's power and expand that civil liberty. Wisconsin versus Yoder is a free exercise case, and this is talking about Amish families that didn't wish to send their children to school or to high school, and they said that compelling Amish students to attend public school beyond 8th grade violates the Free Exercise Clause, the right of the Amish to practice their religion as they wish, and for them that included not attending public schools. It went against their moral beliefs, and so the Supreme Court ruled in their favor. So notice in both of these cases, they expand the Establishment and Free Exercise Clause. All right, now we get to free speech, freedom of expression. When can it be limited? Well, it's supposed to only be limited if it is inciting, quote, imminent lawless action, end quote, and, not or, and is likely to produce such action. So speech that is inciting imminent, about to happen right now, lawless, illegal action, and it's likely to happen as a result of that speech. As a result of that, or along with that I should say, symbolic speech and hate speech are both protected. Again, that line on hate speech is it inciting imminent lawless action? People can say hateful things unless it crosses that line in that first bullet point. Speech that's not protected would include libel, slander, so those are written and spoken lies about a person. Obscenity and fighting words are not protected speech. All right, along with free speech, we have a few Supreme Court cases. Schank versus the U.S. in 1919. This actually limited free speech. So most of the cases you learn in this class are ones that defended and upheld rights. This actually allowed speech to be limited, ruling that if it creates a clear and present danger, it can be limited. I want you to know that this is no longer true. So this case, it's 100 years ago. The clear and present danger test is no longer Supreme Court precedent, but the AP exam wants you to learn this case, showing the idea that speech can be limited, even though that's not any longer the reason it can be. And along with that idea is that the First Amendment does not protect urging unlawful conduct, and that part of it is still true today. Tinka versus Des Moines, another free speech case. So we fast forward 50 years, and we see that students have free speech at school. So this is an expansion of free speech rights. It says that schools can only limit a student's free speech if that speech substantially interferes with the operation of the school. In this case, the speech was in the form of those black armbands you see on the right-hand side there, and the Supreme Court here also said that symbolic speech is protected exactly the same as pure speech, or speech words coming out of a person's mouth. So symbols also protected. All right, New York Times versus U.S. This is a freedom of the press case, so very similar. In this case, again, the Supreme Court is going to rule in favor of the freedom. The federal government was attempting to block the New York Times and Washington Post from publishing the Pentagon Papers, and the Supreme Court rules that the government was not allowed to do that. They say that there is a heavy presumption against prior restraint. Prior restraint means censorship, and so because we have freedom of the press, there should not be censorship, is essentially what New York Times versus U.S. says. All right, so now shifting gears from the First Amendment, we're going to move to the Fourth Amendment. And this is talking about protecting people from unreasonable searches and seizures. So what exactly constitutes a reasonable or a legal search? Well, that will require probable cause, a search warrant, or consent of the person being searched. So again, officers must have probable cause, a warrant, or the person must consent. What happens if they search the person illegally and they find out that that person is in fact guilty of something? They find evidence against them. Well, we have something known as the exclusionary rule. This came about in 1913, Supreme Court case a long time ago, which you don't need to know the name of. And the Supreme Court decided then that illegally obtained evidence may not be used in a trial. So if the police do find evidence against you that they found illegally because they didn't have probable cause, a warrant, or consent, that evidence cannot be used against you at trial. They can still prosecute you with other evidence though, so it doesn't necessarily mean you get away with the crime, but it might. All right, so still speaking on rights of the accused, the Miranda Rule, which we may be familiar with, suspects in custody must be informed of their Fifth and Sixth Amendment rights. So that includes the right to remain silent, protection against self-incrimination, that's in the Fifth Amendment, as well as your right to an attorney, that is found in the Sixth Amendment. So it doesn't actually give you any new rights, it just says that you must be informed of them when you are under arrest. There is an exception to this in the last couple of decades, and it's known as the public safety exception. And so if police were to ask a question to neutralize a dangerous situation and the suspect responds voluntarily, even though they haven't told them the Miranda rights, that statement can be used as evidence. So it's very specific. It has to be, in that moment, it has to be a dangerous situation. But in that case, they don't have to Mirandize the person first. They can ask the question and can use the evidence if they answer. All right, so again on the Sixth Amendment now, we have Gideon versus Wainwright. We know that the Sixth Amendment declared that you have the right to an attorney. It also says you have the right to have one provided for you, and that, remember, only applied to the federal government initially. So this is an incorporation case. It incorporated the right to an attorney, meaning that now states also have to provide a defendant with an attorney if he or she cannot afford one for himself or herself. All right, so moving along to a right of privacy. This one is interesting because it's not anywhere directly stated in the Bill of Rights, so nowhere is it enumerated. The court discovered the right of privacy in Griswold versus Connecticut, and then they used it in Roe versus Wade to establish abortion rights. So the next slide will talk a little bit more about Roe versus Wade, but again, this idea of a right of privacy, it is a real right, it does exist, however, it's not directly stated, which makes it a little bit more controversial than pretty much anything else that is directly stated. So Roe versus Wade, it was based on a right of privacy, and it ruled that states cannot ban abortion. From other cases that happen after this, we know that states can limit abortion, but they are not allowed to ban it outright. All right, and then one of your big picture things, this is a copy paste from the College Board. Debate over the balance between freedom and security is exemplified in gun rights, gun control debates, as well as debates over government surveillance of electronic metadata. I have a couple of great videos you can check out to get more about those debates specifically, but this is kind of a good context to think about this idea of we want both freedom and security, and so on which side do we err is essentially what this is about. And so gun control versus gun rights is one area for that debate. Another is the government surveillance. All right, so speaking of guns, we have McDonald versus Chicago, 2010, a very recent Supreme Court case, less than 10 years old at this point, and this incorporated the right to bear arms. So it's important to note that a case that came just 2 years before, DC versus Heller, it said that individual people have the right to bear arms, so you don't need to be part of a militia to have that right to bear arms. It can be for self-defense. And now this case went a little bit further and said, and by the way, states can't take away that right either. So McDonald versus Chicago incorporated the right to bear arms. All right, so now we shift gears towards civil rights. Civil rights, now we're talking about constitutional protections from discrimination against groups of people. So notice two main differences between civil liberties and civil rights, because I don't want you to use those terms interchangeably because they do not mean the same thing. Civil liberties allow an individual to do something that he or she wants to do, whereas civil rights are protecting groups of people from discrimination. All right, so some kind of group characteristic is at play here. It can be race, it can be gender, it can be sexual orientation, something like that. And others are trying to discriminate against people from that group. And civil rights is what's going to try to prevent them from doing so. All right, so we have a history in this country, unfortunately, of legalized discrimination at times. So things like black codes, Jim Crow laws, that's post-Plessy versus Ferguson, which were state and local laws that essentially codified or legalized segregation, allowed there to be supposedly separate but equal facilities for black and white people. After the Fifth Amendment, which said that race can no longer be a barrier to vote, well, a bunch of southern states passed things like poll taxes, literacy tests, white primary, grandfather clause, in order to prevent black people from actually being able to exercise that right to vote. So a poll tax, this was a small fee that would be required to be paid in order to vote, knowing that many former slaves would not be able to pay that fee. Literacy test, again, knowing that literacy rates were low at this time, they require a literacy test, which was actually much, much more difficult than a standard literacy test. It was clearly an obstacle to prevent people from voting. White primary said you could only vote in primaries if you were white, and initially that was allowed because that was viewed as a private election, because the winner doesn't take office, the winner just gets to be a candidate for a party. And the grandfather clause was this exception that says, all right, but if you or a relative, a grandfather, could vote in 1867, when black people couldn't vote, then you can vote even if you can't pass the poll tax or pass the literacy test or pay the poll tax. Intimidation, threats, violence also used to try to stop black people from voting. All right, so we have on the flip side of that the expansion of voting rights. You have those amendments, which hopefully you should know at this point. If you don't, make sure you do. 15th Amendment, black men gain the right to vote. 19th Amendment allows women to vote. And the 26th Amendment changes the voting age to 18. Even more recently, the Voting Rights Act of 1965 and the 24th Amendment together are going to be what actually allows minorities to finally be able to really, truly exercise their right to vote. It banned literacy tests and other obstacles to vote. And it also required states that have a history of voting discrimination to obtain federal approval for any change in their election laws and policies. The 24th Amendment banned the poll tax, and so those two policies taken together greatly expanded African American voter turnout. All right, so social movements sometimes can affect public policy. The civil rights movement is a good example of that. So in the 1960s, we have the civil rights movement, which led to the passage of the Civil Rights Act, the 24th Amendment, and the Voting Rights Act having a major impact on policy. The women's rights movement of the same era led to the Equal Pay Act of 1963. Again, women are protected by the Civil Rights Act of 1964. and then Title IX of the Educational Amendments of 1972. The Civil Rights Act is one of the most important pieces of legislation in American history, and for this course, it banned discrimination based on race, color, gender, religion, or national origin in public accommodations or employment. Essentially, that means for jobs or for places that serve the public, like a theater, like a park, like a bus, like anything like that, a restaurant, that they now can no longer engage in discrimination against those 5 protected classes of people. Affirmative action refers to preferential admissions and hiring policies for minorities. It is still allowed, and by the way, schools don't have to have affirmative action policies, but they can. But if they do, race is only allowed to be a factor. It cannot be the factor for admissions. Schools cannot use a racial quota system, meaning having a certain number of seats reserved only for minorities, whether racial or gender, and they cannot award points for race towards admission. This brings up a very important question that again could be likely an essay topic. Does the 14th Amendment prohibit any race-based legal distinctions, or does it merely prohibit race-based legal distinctions intended to harm minorities? So clearly affirmative action makes a distinction based on race. Is that okay because it's intended to help, or is it not okay because it violates the Equal Protection Clause? Alright, if you haven't already, make sure you subscribe, hit that like button for me, make sure you check out the rest of the series reviewing you for the AP exam. Until next time, this has been a La Money production.